Hey, this is Brian Parker coming at you with a new video, and this is one I just did for a client again. I'm doing a lot of these where a client comes in with a case and then I file it and then I bring it to you so you can see hot off the presses, the very latest way. To be honest with you, while I do evolve and add new things to my complaints, 10 years from now, this will still be good. I don't know if I'm still going to be here, but this stuff will be. And it will be helpful because things don't change in the debt collection industry as far as fraud and deception and changing words or definitions. Remember the word definition today. So this is a hack of a Unifund CCR LLC debt collection lawsuit that a client I represent. This is his defense straight to you. He's a member of our website, a proud member, and he's contributing. He's a great guy, and I'm going to do the best I can for you and for him and for the membership site. So who is Unifund? By the way, I've never done a Unifund video, I don't think, so this will have a sweet special spot of its own on our membership site, collectionstoppersolutions.com. But for everyone, YouTube channel subscribers and members, this is it. So I'm first going to give you the summons, complaint, and usual lawsuit. I say usual because Unifund does it the same way. And they've added a few things. I want to show you some cool things they've done. Cool for you, not for them. So let's look at their summons. Shazam, Shazam, or Shazinski. Boom. And look at that thing. These show notes are going to be on my membership site. I read directly from them if I really want to make sure I give you everything. But cool. Look at what I've circled on the caption. They voluntarily say this is a communication from a debt collector, an attempt to collect a debt, and any information obtained will be used for that purpose. The last video I just did, let's put it in the sky, on why they put Mini-Mirandas in these things increasingly more and more. How to make a creditor a debt collector is the title of the video I just did. Let's put it up. Take a look at that. And then I'm going to go swoosh. And you can see it's put up the caption again if it's not still up. I always talk to the screen. It's just a green thing. It's not even that. But Cindy, my editor, does this work and tries to stay up with a maniac mind. So if you look at the summons, they've got the actual words. Now, that's not required under any law that I know. It's a federal requirement, as we'll go into that, as my video went into that. Why are they doing that? Because, and I'm going to quote a Second Circuit case. When a debtor receives information that a debt collector is involved, their knees knock. And they've now been told that the price of poker just went up. That's purposeful to scare the person receiving that. But in a lawsuit, it can have dramatic ramifications and consequences, as I said in my video yesterday. Look also, let me just put this up. I'm going to put at the bottom of the summons, Shazam, and look at the date that's filed, 12/19/2023. So already this is a whole plate of wrong just on their first page that the debtor receives. Now let's put up the actual lawsuit first page, Shazam. And there you go. Circled is this, what's called, get used to this if you don't know it already, the Mini-Miranda warning. It's called a warning for a reason. It's a requirement under the FDCPA that every debt collector communication must and shall, two words in the law. If you ever see a statute or a law that says may, somebody, may, may means it's a suggestion, you're not breaking any law. But if you ever see the word shall, anytime you see the word shall, and by the way, that's from our Constitution all the way down to today, the word shall is you must. It is illegal not to ignore this. So You shall not put this on a debt collection pleading under the Fair Debt Collection Practice. I showed you that in yesterday's video on making a creditor a debt collector. They become debt collectors when they don't want to be, when they put something like this on, because they think they can put this up and scare the debtor, their knees knock. And if you're a creditor, you can say, oh, creditors aren't covered under the FDCPA. Well, you just became a debt collector, and you can't shy away from that. That's only for debt collectors. So Unifund, which will claim it's a creditor at some point, is saying we're debt collectors. Actually, the attorney put this on there to protect himself or his firm or their firm. But it has grave consequences because it's not from the attorney, it's from the party. So that's already something weird is happening there. This lawsuit is supported by an affidavit. That affidavit, I will put that affidavit on the screen, Shazam. Look at the affidavit. This is a person, a Mayo Zan, and I've checked her out. She's from Unifund in Cincinnati. And why does she need to see? You see the circled, this is a communication from a debt collector, yada, yada. Why does she need to say that? She's not a debt collector, but it's in the caption of this affidavit. Now we're going to see why that's wrong too. There is no evidence, as you can, let's put the first page of the complaint up first page, boom. And you can see the word account is all over this. In fact, they go, the original creditor in paragraph 3. Let's put up a paragraph 3 alone. Shazam. You can see the original creditor account number, and now they call it the account. When you, again, parenthesis, a special lookout, hey, look, we're going to now call this account. From then on, they don't have to keep explaining themselves. But they didn't put the word debt. This is a debt. You cannot sue on an account. You can have an account stated and backed up by an affidavit, but it still must be a debt. Otherwise, they'd be called account collectors. All right? So remember account, remember debt, and remember the word definition. I know that's weird, but so there is an affidavit attached. I showed you the affidavit. Let's put it right up. First page, Shazam. And you can see it's an affidavit from a Mayo Zan. This is sworn under oath on November 20th, 2023 from the Cincinnati office, all right? It fails to say in this affidavit that this is a debt or who assigned the debt to Unifund, Miss Zan's employer and supposedly the owner of the debt. It says in paragraph 5, let's put up paragraph 5 of her affidavit, Shazam. When the account was assigned to plaintiff, blah, 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 balance, following assignment, blah, 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 payments of 0 were not received. So they can't even say who gave them the debt. And we're going to see why in a second. And they never can. They never put in the affidavit who gave what to whom, just that their guy, the best you're going to see is predecessor and interest sent it to whoever the affiant is employed by. So why, and as I've said before, there are thousands of these affidavits. I've actually done cases, several cases, where the same person, same date, same stuff, same affidavit, just changing the client's name has shown up. I'm like, oh my God, this is a mill. It is a mill. They put out hundreds of thousands of these. So this has to be very general. Otherwise, their machine breaks down and their profits go down the toilet. So this is signed under oath 30 days before the lawsuit. Let me put up the bottom of the summons. Boom, Shazam. And you see 1219. And let me keep that up there, Cindy, and put up the bottom of the affidavit. And you can see that was signed the 20th of November. So 30 days later, that's numerically 30 days, the lawsuit was filed with the court. What does that mean? Well, she's attesting to things in the complaint. She literally says, And I do this without my glasses because I'm vain. But I've reviewed the records which plaintiff keeps in connection with defense account defined in the complaint. Now keep in mind, that person's not a defendant. My client's not a defendant on the 20th of November. So that's false. And how is she looking at a complaint that hasn't been filed yet and swearing under oath about it? I will tell you that the complaint was created on the 27th, but it wasn't filed till the following month, December. Still, that's 7 days before the actual complaint is created, but officially my client and Unifund is not a plaintiff. I am pointing these small bricks out as they become walls for you to use in what? What's the most important part attached to these things? Correctamundo, the counter affidavit. You will see the counter affidavit in this video attached to my membership website. You'll see the actual answer I filed for my client with all the stuff I'm telling you in the answer, in the counter affidavit, plus their exhibits, plus a very important case, Green versus PRA, which locks up all this work for you and helps you immensely. Let's see further paragraph 4 of her affidavit. I hope this is not getting boring, but this is in my head. So Shazam, she says the account records, again count, there's no debt, kept in the course of plaintiff's regularly conducted business activity. That's her to get it, her idea of how to get it in through 803.6 hearsay exception to this being hearsay, business records exception. Here she goes. Based on my review of the account records, the definition of the account. We talk in terms of what's an account, what's a debt. Hey, and Parker says videos ago, go look at what the definition of each and how they're not the same. They're almost mutually exclusive. You can't sue on an account. She throws the word definition. So let me just throw the definition at you. In fact, I'll put it up. Shazam. It is essentially an account is a detailed record of all the money that the business or person receives and spends. So is an oil change record. That keeps oil change records. So is, hey, I change the tires every 40,000 miles. So that's not something you sue upon. In double entry bookkeeping, every debit or credit in the account is also represented as a credit or debit somewhere else. That's accounting 101, right? That's not a debt to be sued upon. And as I said on paragraph 4, she says, look at the definition of account. We did, and it's not a debt. The definition of a debt is defined by the Fair Debt Collectors Practice Act that Unifund is governed by. Every debt collector and creditors, when Parker gets involved, that is covering the debt collection practices of every debt collector and creditor under 15 U.S.C. 1692A. Put it up there. Thank you, Cindy. This definition is brought to you by Cindy. Anyway, so the debt means any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance services are the subject of a transaction primarily for personal, family, and household purposes. I took the entire statute and said search term for account and also for receivables. It ain't there. A debt is a debt, and accounts is an account. Receivables are receivables. There's nothing to be sued upon or assigned. So this, there are no account or receivables in the definition I put in my show notes. By the way, again, my show notes are attached to the membership video. They're helpful as far as the reason why I'm doing this is to provide you instructions how to properly answer in this case, a Unifund collection lawsuit. Again, this is my task-related video saying if you're going to go to solo suit, you're going to get nothing. If you're going to go to all these square deal Dans online telling you how to answer and you pay for them, solo suit, by the way, is doing something really bad. I just need to find time to do a class action against them. But you're not going to, if you follow the way I do my stuff, and that's your choice to do that, I'm not advising you, I'll show you every way to do this the best way. The caption of the affidavit and the lawsuit, remarkably, are the same, even though they're filed 30 days apart. Neither one is looking at the other. And they both have this Mini-Miranda in them that the law does not require, especially doesn't require it on the summons. Why does the affidavit need to say it's from a debt collector? It doesn't. Let's look at the bill of sale. I've done entire videos just on bill of sales. See my videos on bill of sales. Circle it, swish. And here it's something really cool. I'll just get right to it. Let's put up the first paragraph of the bill of sale, Shazam. And here's where you win your case. Reading is fundamental. Just read these things, because my other mantra is, waiting for it. That's right again. You win a silver. Oh, you win a gold, because you're right, you're first. Use their documents against them. So let's do that right now. And you can see that they're saying this is a bill of sale pursuant to the forward flow debt purchase and sale agreement. You're never going to see that. And if you push hard in discovery, you'll settle the case, because they don't want you to see. Essentially, they're saying, we're giving you, Unifund, this debt. It's yours. And the longer you have it, the worse it's going to smell. It's just like a fish in your trunk that you forgot about. But here's the smelly part. And just look at the name of these things. The original creditor, First National Bank of Omaha, and this is true, Distressed Asset Portfolio 3 LLC, DAP3. DAP3 hereby direct sales, seller agrees. The seller hereby transfers, sells, conveys, grants, and delivers to Distressed Asset Portfolio 4, or DAP4, DAP3's affiliate and successor and assignment respective Pool 6. This is just getting out of control. And remember, we talked about this previously. Without recourse, meaning we're not legally responsible for this. If you're giving away something where I just want to make this clear, you can't sue me. It's as is. It's a piece of shit. All right? Cindy, don't let that come on the air. And to the extent of seller's ownership of such a pool, to the extent, meaning we're not even sure it's fully owned. The receivables, again, I said receivables aren't accounts, and accounts aren't debts. So they're saying, DAP3 is saying, here, DAP4, go forth. And eventually they're going to have a bill of sale that DAP4 gives it to Unifund. So what? Well, DAP4 doesn't own anything. Where's the bill of sale or assignment to DAP4? This is where you get them every time. It should be original creditor to DAP3, to DAP4, to Unifund. Let's kind of put that on the screen. So for a sound, clear, proper, perfected, the actual word is perfected chain of title, we'd have to have original creditor, arrow to DAP3, arrow to DAP4, arrow to Unifund. That is how it should go, but nothing here shows how DAP3 has the right to, and I quote, transfer, sell, convey, grant, deliver to Distressed Portfolio 4. So that's a breakdown of that nonsense. So there's no assignment of proof. The Distressed Asset Portfolio 3 has the right to transfer anything. There's no forward flow agreement. If you answer and it gets kind of litigious, do a discovery for the forward flow agreement. They'll put up a lot of nonsense and that'll stop that case, because they don't want you to know what's in there. One of the things that's in that forward flow agreement, it'll say, we're giving you this debt without recourse, but we're also not making any representations. We're not giving you any warranties. Don't buy a car if it doesn't have a warranty as is, and it's called distressed Pontiac Shazam. You're not buying that, okay? Or you're paying pennies on the dollar like these companies do for absolute... Oh, did it again. Cindy fixed that. So that you can't sell receivables, they're not debts. Now, that perfected title I told you about, 1, 2, 3, 4, I go, original creditor, let's put it up again. Cindy, original creditor, DAP3 to DAP4 to Unifund. Each assignment must have a affidavit saying the debt of Mr. whomever, my client data, is in this with account number, in this with account number. You can see just from the bill of sale alone, let me put it up again, Cindy. Bill of sale doesn't have any notarized certification, they're electronic signatures, interesting dates, but you have to have it certified because this is just hearsay. So they, and I'm going to be fair about this, they have attached a receivables data file. By the way, you can't sue on a receivable. And here it is. Let me put it up, Cindy, Shazam. And you can see, but it's called an extract from receivables data file from Bank of blah, blah, blah in connection with its sale of accounts to distress 4. They forgot to mention 3 there. I wonder why, because we just talked about that. It should be from 3 to 4, even if they had the right stuff, they haven't. So, interesting. Anyway, so there's my client name, account name, and there's the last 4, which is fair. But the major case in this arena, and I beg you to read this case. It's long, but you'll learn about, you could do my entire practice just on the green versus PRA. And it's all about how important assignments are and the form of assignments. It's a major case. And I'll quote the court and then you'll go to sleep. I'll put it up. Green versus PRA, Shazam. In sum, we hold. When a court holds, it's making a decision. So an attorney, sometimes you'll be waiting on this important opinion or ruling of the court. He'll go right to the bottom and look, we rule or we hold. He doesn't going to care how they got there. He wants to see if he won or not. So you always run to the, in sum, we hold. That means in conclusion, let's see if you won. A plaintiff who asserts ownership of a debt by assignment, and the plaintiff in this case would be Unifund, in that case, PRA, must produce evidence for each and every assignment. Remember we talked about each one has to be sound, showing the chain of title for the debt passed from the original assigner to the plaintiff. In our case, in this case, nothing went to DAP 3, so DAP 3 can't give it to DAP 4. In fact, their own receivables data file that they attached as proof that my client's debt is in this doesn't show up. There's no assignment. Sorry, I didn't mean to break. Showing the chain of title for the debt passed from the original assigner to the plaintiff. At a minimum, such evidence must show the defendant's account number along with other relevant identifying information was included in the assignment, meaning has to be in the assignment, as I always profess. But they get a little wiggle room here. An attachment to the bill of sale, like we just talked about, listing account numbers and other identifying information that traces back to the bill of sale must be by affidavit. There's no affidavit in the thing called receiver's data file, and it fails to say anything about DAP 3. So that wouldn't work in this case. You have no assignment. That extra piece of paper by its own is called an extract. Now, all this goes into what? What does it go into? There's only 2 things I ever mentioned. The counter affidavit, please. Hey, I wish somebody would profess to me that I must use a counter affidavit and then give me a copy. Your wish is fulfilled. Attached to this membership will be a copy of the counter affidavit I used in this case, as I always do for you. And as I always do for you, I'll put it up on the screen, Shazam, and you can see how everything we just talked about basically finds its way into the counter affidavit. This is you coming out. This is telling the court you're not just denying anything. You're showing soundly that you know the law, you know your case, and you know they're wrong. Again, I've also attached on my member site the actual answer with the counter affidavit, with their lawsuit, circling everything I just did. I'm showing you hot off the presses how I smacked these guys around. So attached to the membership site will be a Word copy of my answer for you to use the way you use in your state. I'm not telling you how to do it. It is a template. Also, my counter affidavit, the actual answer, my show notes, and pointing out exactly how they the bed. I just love doing that. Cindy, beep it out. When they showed you that they own the debt and they don't. Volunteering the Mini-Miranda role just tells you there's something going on. They're always protecting themselves at great harm to their clients. As I said in my video yesterday, let's point to have the box of the video yesterday, Cindy, and also the video how Discover Bank did the same thing by adding a Mini-Miranda to their lawsuit and other things, so I make them debt collectors. So just a brief primer. A creditor is protected from the FDCPA and essentially protected from jerks like me and great people that are smart and watch my stuff and read and learn like you. But if they take on the characteristics of a debt collector, they are no longer shielded from the immunity of being a creditor, meaning FDCPA. We always want to use the FDCPA or any state statute. Look into your state collection statute. For example, Florida is actually better than the national FDCPA in that it has a 2-year statute of limitations, and they include creditors. I got a nice little class action going in Florida, by the way, on something like that. So I know a little bit about that. But your state statute may be better than the FDCPA that says, yeah, it's a great, better statute of limitations. Also in Florida, you can get money damages for punitives, meaning punishment. Whereas in Michigan, the only person that's winning under the Michigan statute are the attorneys. And I throw it in there because you get $50 per violation, but I'm aiming for the FDCPA. So creditors are immune from FDCPA unless they take on the characteristics like I allege in all my videos. Show that video I did on Monday, Cindy. Show the video I did just yesterday that dropped about how creditors become collectors. Okay, let's get those out of there so you can look at my lovely face again. Shweesh. So attached to my membership site, I'm going to end this now. The Counter Affidavit, the green case, Unifund's actual complaint and exhibits, and my actual answer exhibits filed in response on my membership website. I threw in another bonus for you. In Word, and I'm going to have to do a video on this because I talk about it too much, but it's very powerful. What I'm about to say to you is very powerful to settle cases. A counterclaim. If all what I've said is true, and it is, because we use their documents against them, do a counterclaim. Depending on your feelings about it and if it's worthwhile, it settles cases. And so what I do when I offer to settle a case with a debt collector, I'll go, here's my answer and all the reasons why you suck. If you settle this within 7 days, I won't file a counterclaim and cut down on everybody's costs. And if they don't, you have to follow up. Never make threats, because that's what debt collectors do. They make threats and then they don't really do them. They make them again. Never make a threat unless you're backing it up. There's actually a statute, part of the FDCPA, that says you made a threat and you didn't back it up, essentially. And that's a violation. And that makes sense. But don't you ever make a threat, regardless of whether it's a violation. You want to be the good guy on the white horse. You want to have clean hands. Remember we talked about the old axiom, you come to court with clean hands. You don't want dirt. Oh, I'm okay with my nails. You don't want dirt under your nails when you're alleging that you're a good guy. So all that stuff, I'll have a Word counterclaim that I used in this case that you can play with. If it works for your state, fine. But if you threaten a counterclaim if they don't settle, you got to do it. So don't threaten, and that's a good basis. So I threw that in as a bonus on my membership website. I thank you very much. This one was a long one, but I hope you can take all the nuggets in it. Unifund's one of those where you've kind of got to push them a little and then they suddenly understand what's going on. I've done them, I've sued them a lot. They're one of the old debt collectors. Not old and old, but old debt nasty. Look, some of the debt is called distressed. The actual name of the company has the word distress in it. That's a hint and a half for your tuchus. Don't believe that. Thank you. If you like, if you love, subscribe and let me know with a thumbs up I'm doing all right, because I am doing all right the more I hear from you and the more I do for you. And I thank you very much. Have a fantastic day.